utokee uwajibishaji ili hayo yote irudie, ili Tanzania tuna amani toka kizazi na kizazi. Amani yetu tuilinde, ni muhimu sana. Lakini pili, kupitia maafisa usafirishaji kama ulivyosema mama, walitokea wengine waendesha pikipiki, lakini maafisa usafirishaji kama maafisa walivyo hawakufanya hivyo vitu. Wao waliotokea ni watu ambao waendesha pikipiki, hawajui walikotokea. Lakini tukuhakikishie mama, eneo letu na taasisi yetu tunaendelea kukuunga mkono juhudi zote, na amani itaendelea kuwepo juu ya Tanzania. Nikushukuru sana.
Asante sana, asante sana. Mawinga. Machinga. Naambiwa kuna na mawinga, sio? Mawinga ni kina nani? Wapiga debe? Machinga. Haya.
Mheshimiwa Rais wa Jamhuri ya Muungano wa Tanzania, kwa majina anaitwa Christian Msumari, ni mwenyekiti wa Machinga mkoa wa Dodoma.
Sawa sawa baba.
Mheshimiwa Rais, cha kwanza kabisa napenda nikupongeze na tukushukuru kwa muda huu ambao umetenga kwa ajili yetu. Tulipambana sana wakati wa uchaguzi mkuu kupata nafasi ya kusalimiana na wewe, lakini ikashindikana. Tumepambana sana na mkuu wa mkoa, mkuu wa wilaya na wasaidizi wako kuwaomba, jamani, leo vyovyote itakavyokuwa tunamsubiri mama barabarani na lazima tumuone. Mheshimiwa Rais, mimi kama mwenyekiti wa Machinga mkoa napenda nikushukuru kuanzia ulipotoa maelekezo ya upangaji wa wafanyabiashara ndogo ndogo Tanzania. Ulisema tushirikishwe na tupangiwe maeneo mazuri ambayo salama kwa biashara zetu. Mheshimiwa Rais, tuna soko la Machinga Complex Dodoma ambalo ni soko la mfano wa kuigwa Tanzania nzima. Imetumia zaidi ya bilioni 9 fedha ambazo ongezitumia hata kujenga madarasa na vituo vya afya, lakini ukasema wanangu wa Dodoma waende wakakae mahali pazuri. Na kwa kupitia hilo Mheshimiwa Rais, sisi Machinga wa Dodoma tuliweza kutoka barabarani wenyewe bila mgambo, bila polisi, 100%, tukahamia sokoni na tukaacha maeneo yote wazi. Tulifanya hivyo kwa sababu ya utii wetu wa serikali na heshima yetu ya serikali na kukusapoti Mheshimiwa Rais kwa vitendo. Mheshimiwa Rais, tunakushukuru, umejenga ofisi za Machinga mikoa yote, jambo ambalo halikuwahi kutokea. Hatukuwa na ofisi za sehemu za kufanyia biashara. Mheshimiwa Rais, umetenga bilioni 200 kwa ajili ya wafanyabiashara ndogo ndogo kupitia benki NMB, na mkopo na riba yake ni 7%. Na Mheshimiwa Rais, tusipowasema haya watu watahisi labda sisi Machinga sasa hivi ni Machinga wa zamani ambao tunateseka. Hapana. Mheshimiwa Rais, fedha hizo anakopeshwa mamalishe, babalishe, bodaboda. Anakopeshwa mtu mmoja mmoja bila masharti magumu. Lakini nakuomba tu jambo moja, kwa kuwa fedha hizo ziko chini ya NMB peke yake, kwa sisi wa Machinga kuna lugha tunasema ana monopolize ugawaji wa mikopo kwa wafanyabiashara ndogo ndogo. Ni vyema fedha hizo zikagawiwa pia kwa mabenki mengine ili kuwe kuna ushindani wa utoaji wa mikopo, Machinga tuweze kupata kwa wingi. Mheshimiwa Rais, wakati tunajenga soko ile la Machinga, tulihamia Machinga wote, ila kuna wamachinga wenzetu wachache ambao wao wanatoka sokoni wanaanza kurudi mtaani. Tunaomba mkuu wa mkoa, mkuu wa wilaya, mkurugenzi wahakikishe wamachinga wote wanaorudi mtaani warudishwe sokoni. Tusichafue taswira ya jiji letu la Dodoma. Wote tukae kwenye soko moja zuri la upendo. Mheshimiwa Rais, uliagiza pia daladala zote zianzie na kuishia soko la Machinga. Wanafanya hivyo, lakini pia kuna zile daladala chache ambao wanajifanya wajanja, wanapaki baadhi ya maeneo. Tunaomba wasituharibie utaratibu wa mkoa wetu. Barabara zipitike, maeneo ya wache wazi, daladala zote zipaki, soko la Machinga zianzie pale na ziishie pale. Pia Mheshimiwa Rais, ulitutambua kama kundi maalumu na ulituweka chini ya Wizara ya Maendeleo ya Jamii. Mheshimiwa Rais, sisi wa Machinga na sisi yani wafanyabiashara ndogo ndogo wote tunafanya shughuli zetu chini ya wakurugenzi ambao wako chini ya ofisi ya TAMISEMI, masoko chini ya mkurugenzi na shughuli zote, wakuu wa mikoa, wakuu wa wilaya. Kwa hiyo mwisho wa siku bajeti ya Machinga iko Wizara ya Maendeleo ya Jamii, lakini mzigo mkubwa wanaubeba TAMISEMI. Ikikupendeza, tunaomba uturudishe TAMISEMI ili wakuu wa mikoa, wakuu wa wilaya na wakurugenzi waone jukumu hili ni la kwao la msingi na shughuli zote ziende vizuri. Baada ya kusema hayo, Mheshimiwa Rais, mimi kijana wako Naitwa Christian Msumari, ni machinga mwandamizi, pia ni msomi. Na Bachelor Degree of Business Administration in Health Service Management. Asante sana, Mungu akubariki.
Asante sana, asante sana. Machinga we. Bwana, hatuna machinga wababaishaji sasa hivi. Machinga wasomi kweli kweli. Na biashara sinaenda, mambo yananyooka. Business administration inafanya kazi. Nashukuru sana. Babangu, na we machinga pia.
Kwa majina naitwa Marco Simoni Mhagale, ni mwenyekiti wa soko la Machinga Complex hapa.
Okay.
Nina wafanyabiashara 4500. Mwenzangu mwenyekiti wa mkoa amenifilisi mengi.
Okay.
Lakini Mheshimiwa Rais na mimi niombe hayo, lakini mawili ambayo ni msingi na tusumbua sana kwenye soko letu.
Ndio.
Kwanza, amani ya nchi tunaipenda, hata sisi tunailinda, na ndio maana sisi hatukuruhusu kwenye soko letu itokee chanzo chochote cha fujo. Tulipambana wenyewe na serikali ya mkoa ilitusaidia na mambo yalienda vizuri. Tunaahidi na tunalaani haiwezi kutokea, na tutakuwa wa kwanza kupambana vurugu isitokee kwenye soko letu. Tunaomba hawa watu ambao wanatoroka sokoni wanarudi mtaani, basi utoe maelekezo kwa serikali ya mkoa iweke mkazo, kwa sababu wale watu wamekuwa wabishi na wanasababisha kule ndani, na wengine wanatamani kurudi biashara ndani na kuwa ngumu. Lakini kwenye swala la daladala nyingi zimeanza kulikwepa soko, na pale tuna watu 4500, wengi tunategemea kuuza ili tuishi. Sasa kuuza kwetu kunakuwa kugumu kwa sababu wateja wanakuwa hakuna. Kwa ukitoa maelekezo daladala zikaingia, tunaamini jambo letu limefika sehemu sahihi, ambapo ni wewe mama, tulikuwa tunakusubiri sana muda mrefu. Maadamu umefika leo, tunaomba mambo yetu ya mbele. La mwisho ambalo sio muhimu sana, tuna korongo kubwa ambalo liko mbele ya soko letu. Lile ikitokea ukamwezesha mkurugenzi, basi tujenge soko jingine ambalo litasimama pale ili lisaidiane kubeba wafanyabiashara ili wasirudi kwenye maeneo yasiyo rasmi. Naomba sana Mheshimiwa Rais, asante na kupongeza. Mungu amekuteua wewe, ana sababu, kwa sababu maandiko yanasema anayemteua yeye hawezi mwanadamu kupinga. Maadamu wewe umeteuliwa na Mungu, hakuna yeyote wa kukuyumbisha. Mungu akupe maisha marefu mama.
Amina, amina babangu, amina. Dodoma oye. Vijana oye. Na wenyewe wameyasikia. Sasa nalofanya na kwenda kufanya kazi za kitaifa, nikirudi nitawaita nijue wamefikia wapi kwenye utekelezaji wa haya. Wamefikia wapi kwenye utekelezaji wa haya. Lakini wahakikishie vijana wangu, nimelisikiliza lile la mkopo kutawanywa kwenye mabenki mengine. Tumeanza kufanya hivyo. Kuna dirisha pia CRDB, lakini walikuwa wanajiandaa kabla hawakufungua. Kwa hiyo tutajitahidi kufanya hivyo pamoja na mifuko mbalimbali ambayo tumeifungua. Vijana ni wengi, tunajua mkopo unatakiwa, na zile bilioni 2 ni za kuanzia. Vijana wangu, jinsi mtakavyofanya kazi, tukikusanya zaidi tutaingiza zaidi kwa vijana, tutaingiza zaidi. Ombi la korongo nimelisikia. Mkurugenzi wa halmashauri yuko hapa? Yuko, amesikia. Na mkuu wa mkoa yuko hapa, mkuu wa wilaya, wote tumesikia. Tutaangalia kwenye mifuko yetu jinsi ya kuwezesha soko jengine la aina ile ili wengine waingie kwenye soko la pili. Lakini leo funzo mlilonipa ni kwamba mnanihitaji rais wenu nizunguke Dodoma. Ndilo ninalolisoma kwenu, kwa sababu mmejua narudi damu, kasema tumvizie hapa. Sasa ni waahidi, nipeni mwezi kama na nusu hivi, na mambo mengi yamenikabili hapa, lakini nikija nitakuja kufanya ziara ndani ya mkoa. Nitazunguka kwenye maeneo yenu nione yale yanayowasibu, lakini nione pia maendeleo yaliyopatikana na vipi tunaweza kuongeza pale tulipofikia. Dodoma oye! Vijana oye! Amani na utulivu kwenye nchi yetu oye! Nawashukuru sana vijana wangu, asanteni sana. Asante sana. Mheshimiwa mkuu wa mkoa, mwenyekiti wa chama mkoa na wabunge, nawashukuru sana. Mheshimiwa mkuu wa wilaya, kamata wilaya vizuri. Nakushukuru sana. Asanteni sana. Nawatakia kila laheri. Watakusikiliza. Maafisa wangu watakusikiliza. Watamsikiliza. Asanteni sana, Mungu awabariki. Haya, asante.
Sorry. Yes, just relax and feel comfortable. If I may say, feel at home also, because this was your home for 10 years. If we could start by asking you to tell us your county and your ethnicity.
Thank you, Honorable CJ. My county is Mandera, and my ethnicity is Somali.
Very well. You know why we ask this very intrusive question?
Yes, Honorable CJ, yes.
Yes, why? Kenyans would like to know why.
It's because of diversity.
Okay, diversity and inclusion and regional balance, which are constitutional imperatives. Very well. Now we'll start. And I want you to tell us who is Justice Wasame, and why do you think you fit this job of Supreme Court judge? When giving us that introduction, we want you to tell us what particular experience you're bringing to this court, skills, knowledge, and we want you to locate that to the jurisdictions that are given to the Supreme Court by the Constitution. If you tell us what experience you have, tell us how it will help you in interpreting and applying the Constitution, in dealing with the matters that come before that court, on general public importance, on advisory opinion, and other jurisdictions. We want you to relate your experience to the work that is going to face you if you are successful as a judge of the Supreme Court.
Thank you, Honorable CJ. My name is, as I stated in my documents, is Mohammed Warsame. I'm a judge of appeal. Currently, I'm stationed in Nairobi from 1st of April. What do I bring? I bring over 32 years of legal experience, which I acquired through advocacy, through the judiciary, as a judge of appeal, and as a court of appeal judge. What are the distinct things which I bring, which will help the Supreme Court? CJ, I bring 5 things on the table. The first thing which I bring is jurisprudential leadership. I have been in the judiciary for over 22 years. I have been a jurisprudential leader as a high court judge and as a court of appeal judge. My jurisprudence has gone all over the country, has gone all over the Commonwealth countries, and one of the key requirements of the Supreme Court is the jurisprudential leadership in terms of the judiciary and in terms of the country. It is the Supreme Court that leads the country in the right direction. So what I bring is that jurisprudential leadership to help the court because I have dealt with all spheres of the law, both criminal, civil, judicial review. I am the first presiding judge of the Judicial Review Division under the current constitution. So I was the first person to interact with the current constitution. Secondly, in that area, when the issue of the recruitment and the appointment of the Supreme Court judges came into question, I was the presiding judge who dealt with that issue in the first instance. Secondly, I was appointed to be the presiding judge in a 3-judge bench, which made that landmark decision. Secondly, CJ, what I bring also is institutional leadership. Institutional leadership in terms that I have been a leader in the High Court, in the Court of Appeal, and also a commissioner for 10 years. Leadership of the judiciary is anchored or is the home of the leadership of the judiciary is the Supreme Court. The Chief Justice is the leader of the judiciary, both administrative and judicial. Secondly, the Supreme Court is also the leader of the judiciary in terms of the leadership, because all the judges of the Supreme Court are members of the judiciary leadership. So what do I bring? I bring the inside-outside perspective of the judiciary, and that will help the court navigate its leadership position as an institution. What that means, I have been a commissioner for 10 years, chairman of the HR for 7 years. I have interacted with the members of the public. I have gone around the country. I know what the Wanjiku needs. What are they expecting from the court? What are they expecting from the judiciary? In essence, what are they expecting from the Supreme Court? They want direction. They want leadership in terms of the resolution of their matters. Therefore, I bring both inside perspective and outside perspective. I know what the Wanjiku needs in terms of how they want the court to lead their affairs. So I bring that on board. The third issue, which is fundamental and which I bring an impeccable record of integrity, which is the hallmark of the leadership of the judiciary and the Supreme Court. We need a court where its record is impeccable in terms of integrity. So I bring that on record, and my record in terms of my integrity is very clear. I have never, in my life as a judge for over 22 years, come into a question where my actions were questioned in terms of my integrity. Therefore, that is a quality which I will bring to the Supreme Court in terms of case resolution. I want, if the issue of corruption is eliminated in the judiciary, that will promote the image and the confidence of Kenyan people in the judiciary. That is one of the pillars, because the Supreme Court sits at the apex. If that issue is led from the Supreme Court, I think the issue of corruption or integrity in terms of this country's expectation will no longer be there. So in order to bring confidence and enhance the confidence of the judiciary and the image of the judiciary, I bring integrity on the table. The fourth issue which I bring is productivity. CJ, I have worked in Kisumu, I have worked in Embu, I have worked in the Milimani Commercial Court, I have worked in the Criminal Division, and I have worked even in the Land Division, and as a JR presiding judge, who was also in charge of the constitutional revision. And one issue which the people of this country want is productivity. They want prompt and efficient resolution of their cases. And that is one issue which I've always put first and foremost in the discharge of my duties as a judge. CJ, I have been, for the last 2 years, I have been the presiding judge of Nakuru. And when I went there, I said, this is how we will work for the people of this country and the people of Nakuru and Eldoret. As a presiding judge of Nakuru, CJ, I was in charge of almost 14 counties. In those 14 counties, there are various disputes. So when I went there, I said to the judges who are working with me, if it is a single judge, we must deliver the ruling on the same day. If it is 5.2b application, we must deliver it within 14 days. And the judgment, we must deliver it in 2 months. We have never failed. For the period of 2 years, I have been there. So that is a pillar. I want to take it to the Supreme Court, such that if that is cascaded to the Court of Appeal, to the High Court, and to the magistracy, we will all be great ambassadors for the people of this country and will improve the image and the confidence of the judiciary. Mm-hmm. The point is, if the issue of productivity is solved, we will be all good ambassadors of the Chief Justice. Mm-hmm. So that is an item which I bring. Lastly, and this is also very fundamental, the Supreme Court is a court that addresses the needs of all Kenyans from all parts of this country. There is a lot of burden and responsibility on the shoulders of the Supreme Court. So what do I bring? I bring diversity. I bring the other eye, the other ear, that can listen to the minorities, marginalized communities, wherever they are. And I will bring the perspective of the minorities and the marginalized community and the diversity. And that is one issue which is so fundamental in the discharge of the duties of the Supreme Court. And as a judiciary, if the issue of diversity is resolved, then the image of the judiciary will also be resolved completely. So CJ, with those 5 issues, if given the opportunity,
6.
Yes, 6 pillars, I will serve with humility, I will serve with distinction and dedication.
Very well. So we are moving on now to another area. So we want you to tell this commission your understanding of the Supreme Court. I believe you have read and prepared for this, but we just want to hear from you. What do you think are the strategic priorities of the Supreme Court, and how can it position itself, like you have said, as a court of excellence?
Thank you, Honorable CJ. The Supreme Court, in my view, is not an ordinary court. The Supreme Court is a special court. It is a special court because that is where the Chief Justice sits as the President of the Supreme Court, and also as the administrative leader of the judiciary. What do people expect from the judiciary, from the Supreme Court, and how can it be a court of excellence? People expect a reasoned, consistent jurisprudential direction from the Supreme Court. And in that regard, the jurisprudence of the Supreme Court must speak to the people of Kenya. It is not the elegance of how the judgment of the Supreme Court is written. It is not whether it is giving commands or otherwise. What is important to the court is whether it is carrying the people of this country on board. And that can only be achieved if we listen to the people of this country through consultation, through cooperation, and hear the feedback from these people. Secondly, the court also must sit with the Court of Appeal judges, with the High Court judges, and with even magistrates, and find out what are people thinking about this court, because this is our court. And this court has been there for the last 13 or 14 years. It has matured. So it must give jurisprudential direction to the country in all matters. And when the Supreme Court issues a decision, people must be raising their ear. And that's what Kenyans expect. You must carry the Wanjikus on board. Mm-hmm. And that is how the court will earn its legitimacy. And legitimacy doesn't mean delivering excellent judgments. The court must be sensible and must address the needs of the ordinary Kenyans and find out whether the court, for example, is dealing with the right issues in the right way.
Very well. I think we'll go to other areas of examination. I don't know whether you attended our conference on celebration of Supreme Court at 12. That is where we were inviting that kind of introspection.
Yes.
What the Supreme Court has done and the views of academia, other judges. I think that will come out in the course of the interview. Now I hand over to Justice Ishare to take it from there.
Thank you very much, Honorable Chief Justice. Honorable Warsame, the second day of these interviews, and in the course of these interviews, we've discussed the issue of how decisions coming from the court, emanating from the court, have changed the course of legal history and also impacted on human life. We also looked at some notable jurisprudence that has also emanated from our Supreme Court. For purposes of this afternoon, I want us to focus on one such decision, and you tell us if it has made certain fundamental or settled some very fundamental issues in our lives that we can say that decision has impacted our lives. And this is the case of the BBI. What did the case of BBI at the Supreme Court settle?
Thank you very much, Commissioner. The case of PPI, I think, settled about 5 issues, or 6 or 7 issues. But
maybe you can tell us 5 that you think are really important.
Yes. The first issue it settled is the issue of justiciability, ripeness, and mootness of issues that were discussed before the Supreme Court, especially the PPI issues. And in the majority, that issue, they said and discussed and said that the issue of justiciability and mootness did not arise in the circumstances of the case. That is the first issue I remember. Secondly, they also settled the issue of the immunity of the president and Article 143 of the Constitution, and they said the Constitution provides and gives the president immunity against civil and criminal litigations. Of course, I was in a bench myself that made a contrary decision just before the current constitution, and where we said where there is a direct and gross constitutional violation. For example, if the president one morning dismisses or allegedly dismisses judges of the Supreme Court or judges of the Court of Appeal, he can be sued. That's what we said in the Olekewa case. which happened before in a 3-judge before this court, and it is cited in the Commonwealth, one of the leading cases on the discipline of judges. The other issue which the court settled is the issue of who can start a popular initiative. Under the Constitution, under Article 255, provides two scenarios, and one which is an appendage to the first two, which is that there is the parliamentary initiative and the popular initiative, and then there is the mixture of parliamentary popular initiative together with parliament. And some of it, the third issue, which is appendage, is the referendum. That issue also was settled. The other issue which was also settled by the Supreme Court is the issue of the quorum of IEBC in terms of receiving and undertaking signatures, and the court said 3 was sufficient. The other issue which was also settled by the Supreme Court is the issue of public participation in terms of the additional 70 constituencies, and the court said there was no public participation. Therefore, that issue cannot be allowed. The other issue which was also settled by the Supreme Court is the issue of the basic structure. And they said basic structure does not apply because our constitution is self-executing. There is no provision to say that our constitution does not provide for instances of amendment. The question is rigidity and against flexibility. So that were the issues which were settled by the Supreme Court.
So in other words, what you're telling us is that if we were minded to amend our constitution, the roadmap has clearly been provided by the Supreme Court.
Yes.
And we wouldn't have to falter again.
Yes.
All right.
The only issue which I add,
yes,
with your permission, in such instances, especially a big case like the BPI structure, what I will propose, in my view, to the Supreme Court, or if I were a Supreme Court judge, we will ask the Chief Justice to write the lead judgment, and maybe the other judges will write a concurring judgment or a dissenting judgment.
Why would you do that?
Because, it is difficult, for example, to read what is the ratio descendi of the PPI in the Court of Appeal, because 5 judges wrote differently, and each one wrote almost more than 100 pages. And in the Supreme Court also similarly like that. So in a very contentious matter like that, for public to understand, because the judgment is not meant only for the lawyers, it's also meant for the members of the public. We should have at least one majority decision, one lead judgment, and then the other judges can either concur or dissent, in my view, for purposes of consistency and for easy location of the ratio descendi of the case.
Judge, does that just apply to the BBI case, or are you saying you're making this recommendation in respect of all other cases as well?
I'm making that in respect of all contentious matters. All contentious matters.
All right.
Yes.
Thank you. Now, let's move to another area. Again, something that we may have alluded to this morning. The doctrine of necessity. When, if at all, did the Supreme Court invoke this doctrine of necessity? And I want to believe that you understand what that means.
Yeah, thank you very much, Commissioner. That is a very difficult area, in my view, of the jurisprudence coming out from the Supreme Court. The jurisdiction on necessity, or the doctrine of necessity, is against the right to fair hearing or the right to recusal by judges. Those are 3 present and coexisting principles. The Supreme Court was called upon to decide on this matter in its early stages in the Rais matter, when it was called to disqualify itself the court laid very elaborate guidelines in terms of when the court can and should apply the principle of necessity. And the court said, because of the constitutional responsibility of the court, and because of the number, and because of the issues involved, and the efficient administration of justice, the court will not easily disqualify itself or recuse from matters. Again, that is also the position that was taken in the matter of Cholet, where judges who have served or who are members of JSC were allegedly asked to disqualify themselves. And the court also returned back to the issue of Rais and said the fact that some of the judges, and it's a constitutional duty of the judges to serve in JSC, they should not disqualify themselves because of that administrative responsibility. That is one line which the court has taken. Then there are two contrary decisions to Rais and Cholet. One is the issue of Tarehe, where the court departed from the issue of it set in Rais and Cholet, and now said because of the allegations of impropriety or bias, the principle of necessity will not apply. And then there is also another case, I can't remember, which also addressed the issue of necessity, and which also went, by the way, I think, I can't remember, but also the judges refused to disqualify them. Yes, this is the case of Rawal, the retirement age case, which paralyzed the court in terms of the fact that 4 of the judges disqualified themselves from the hearing of the matter. And the judges disqualified themselves because some of them were members of the commission and some of them were affected by the retirement age. Therefore, the judges, the matter was not heard and it was left abeyance. So those are the 4 positions, the 4 cases the Supreme Court was called upon to decide on the issue of the principle of necessity.
All right. I want to give you a scenario.
Yes.
Imagine, for instance, and God forbid, that the Chief Justice, a complaint is filed against the Chief Justice, and the matter comes before the Judicial Service Commission, and the Commission makes a recommendation that a tribunal be appointed. And subsequently, a tribunal is appointed, and the Honorable Chief Justice has to face that tribunal. And you know where, if the Chief Justice is aggrieved by the decision of the tribunal, you know where he or she will file an appeal. What are the dynamics therein that you could say would then encumber this case in terms of, you've talked about the right to a fair hearing, yes? And the challenges that are faced by the fact that, this court has only 7 judges, and hence the invocation of the doctrine of necessity. What do you see as some of the challenges that are likely to be faced? And of course, also given the fact that it would appear that the issue of whether the doctrine of necessity should be invoked seems to be a moving target in that court, with all due respect.
Yes, I don't want to use that word because I know my place in society, but for you are a commissioner. That is not a good scenario, first of all. And that is why they should have a dialogue in terms of JSC and the judges of the Superior Court. The question is, a scenario where the Commission is sending its chair to a tribunal is very grave in my view. And that scenario God forbid, should never rise, in my view. But if it ever rises, all judges, and the judges, you know, they have the right to sue in any court. So the Chief Justice can approach the court as an ordinary person who has been affected by that decision, aggrieved by that decision. The Supreme Court judges, of course, we are all human beings, and people who are close to us sometimes may affect our sense of judgment or our sense of reasoning. But there is the oath of office of all judges. So my view would be the judges of the Supreme Court will look at the matter with correct lenses and look at the law and the evidence and give a correct decision in terms of whether the transgressions accused against the Chief Justice is right or wrong. More importantly, in the decision, some of the decision which went to the Supreme Court, the Supreme Court exonerated a judge and said, no, this matter has not reached the threshold of gross.
I am looking at the question of being a judge in your own cause.
Yes. You see, there are two issues. The right to a fair trial. The Chief Justice will not, of course, sit in the case. There will be judges, 6 judges who will sit. The quorum of the court is 5. And those 5 judges will hear the matter objectively and arrive at the correct decision in accordance with the Constitution and the law. That's my view.
So if 6 judges were to sit as opposed to 5,
yes,
and there is a tie, what happens?
If there is a tie,
yes,
the Chief Justice will be back.
All right. Yeah. Right. Finally, from me, you've spoken very, very strongly about corruption, and you've told us about your integrity. And of course, there are concerns about the judiciary and the issue or issues relating to corruption. Indeed, there was a very recent report that painted the judiciary, particularly the magistrates, in very bad light in terms of corruption. The recommendations that you would be making, apart from saying that you want to lead from the top, what other innovations, if I can call it that way, that or recommendations that you would be making in the fight against corruption in the judiciary?
Thank you, Commissioner. I think the issue of corruption or integrity affects all of us. And a dent on one judge or one magistrate is a dent on all of us as judges and magistrates. My recommendation and what I said, that is what we need, an institutional leadership. That is, we need to have a connection between JSC, the Supreme Court, and the judiciary leadership. One thing I will recommend to the Chief Justice and to JSC, all the Supreme Court judges are members of the judiciary leadership team. In my view, I will ask the Chief Justice to send these judges outside Nairobi, maybe every month once, to go and monitor, for example, what is happening in Nakuru, what is happening in Mombasa, what is happening in Garissa, such that the Chief Justice can get correct feedback and the JSC will act. It is not possible for the Chief Justice to supervise every court. When we were few under Gisheru, that issue was very easy because we were less than 40. We were less than 40. And we were supposed to file our returns every day with the Office of the Chief Justice. The point is, we must have a connection between the judiciary leadership and JSC. And it is not that every case of corruption should lead to a dismissal of a magistrate or taking a judge to the tribunal. We must have a compromise. And we must put mechanism, first of all, to address these issues before they occur. And one way of doing that is constant inspection. Find out, for example, where the courts are starting at 9 in Nakuru. Why? Because I have seen that report says 59% of Kenyans who went to court were asked of a bribe. Is that the image which we want to portray? Are we good ambassadors of the Chief Justice and the people of Kenya? How can we change? The responsibility is not only on judges or magistrates, it is also on JSC to go outside and find out what is the problem. Why are people involved in this kind of issues?
Thank you. Thank you, Judge. That's all, Honorable Chief Justice.
Commissioner Mwansa.
Well, thank you, Chief Justice. Judge, and you can correct me if I'm wrong, Islamic law stipulates that as a general principle that non-Muslims are not permitted to inherit the estate of a Muslim. Now, this principle was affirmed as long ago as 24th of May 2002 by the Court of Appeal, which was then the Apex Court, in the matter of the estate of Ishmael Juma Chelanga. And recently, the Supreme Court established another principle in the case of FAA versus RFM, that children born out of wedlock are entitled to inherit from their deceased Muslim fathers' intestate estate. Now, my question is, to what extent has the decision of the court, that is the Supreme Court, created any conflict, whether real or apparent, between Islamic inheritance law and the constitutional principle of equality? Then secondly, now explain how the principle recently established by the court, that is the Supreme Court, concerning inheritance of children born out of wedlock is to be applied by the Qadhi's courts and other superior courts, considering, one, that Islamic law does not constitute a single uniform code of law, and two, that Islamic law is dynamic and adapts to evolving social, political, cultural, and economic conditions.
Thank you, Commissioner. The issues which you have raised are controversial, but simple and straightforward, in my view.
Yes.
Controversial because the way it was put to the public and the way the case was handled makes the matter very controversial. And that's why I said from the start, there is need for the Supreme Court to organically carry every citizen of this country in its decision making, contextually and textually. And that can only be done if the court hears everybody. And it is not possible for the court to hear everybody. What is this principle? Because the biggest misunderstanding which has been created is that Islamic Sharia, properly understood and interpreted, is pluralistic. There are different perspectives. As you know, Commissioner, this matter started before the High Court, and the judge proceeded under the Succession Act initially, but he applied Islamic law. There were 4 issues which were in contestation before the judge. There was the issue of FAA and the issue of the 2 ladies who were sisters, the Mawasis, and the issue of the last lady, those 4. First of all, Islamic law, properly understood and interpreted, has basic principles in terms of inheritance. Islamic law of inheritance is principally just benefit, fairness, and justice in terms of its interpretation. And it says anybody who departs from those principles of fairness, justice, it is not part of the religion. What am I saying? If this matter, look, my biggest concern, I will say first of all, the first thing is the Supreme Court arrived at a jurisprudentially correct decision. But it has damaged parties who were in that court, in that decision, and the larger Muslim community. And there was a way out under the Islamic Sharia if an opportunity was given to the Qadi. It is not in the place of a party who is seeking inheritance under the Islamic law to question another party. For example, FAA could not question whether the children of the other two mothers were born in this way or not born in this way. It's not her place. Islamic law says, if these children were born, how do you resolve these issues? Islamic law on Sharia is based on two things: inheritance. It is based on marriage and blood relationship, what they call consanguinity. There is nobody who has contested during the lifetime of the deceased that these children were not his. So the question of whether they were this way or that way, because I don't like the usage of that name, because that is a dent that will follow those children to the rest of their life. If that matter was given to the Qadis, that issue would not have arisen, and they will have come to the same conclusion. The point I'm making is the courts should give an opportunity to the Qadis court within the sanctioned constitutional boundaries of fairness and in compliance with Article 24(4), that there should be no injustice to the children or to anybody who is entitled to inherit from the estate of the deceased person. My view is the methodology was wrong from the High Court, because if you see the judgment of the judge of the High Court, he ordered for a DNA, which was not applied by any of the parties. The parties were questioning their status. One was questioning, this one is not married. This one was married. Even the appellant, her status in the inheritance was questioned by the other parties, and there was evidence which the judge discounted, rightly or wrongly, I don't know, that she should not inherit. So the question I'm putting is, don't constitutionalize Islamic Sharia, but allow the constitutionalization of Islamic Sharia to function within the parameters of the four corners of the laws on inheritance. That is, they must observe equality, they must observe fairness, and they must not, the decision must not go outside or in violation of the right of the children and the right of the parties who are entitled to inheritance. My view, therefore, is the court reached at the correct decision jurisprudentially, but the methodology was wrong. Islamic law is not an ordinary set of rules or set of cultural rules. You cannot say, for example, Islamic law is repugnant to justice. The culture of, for example, a Muslim who is a Somali or a Kikuyu can be said, his culture, not Islamic Sharia, is repugnant to justice. Because Islamic Sharia provides for all scenarios. And it says any interpretation that results in operation or harm or injury to the parties before court is not part of the religion.
Okay. So just to conclude that discussion on that area.
Yes.
There is a Court of Appeal decision, Judge in Otieno, Ogo, and another, I don't know whether you are aware of it, that permitted the derogation from the right of equality and freedom from discrimination on issues of adoption, marriage, divorce, burial, and devolution of property upon the death or other matters of personal law. Now, that derogation was allowed for all communities in Kenya. Now, I want to ask two questions, and I think you've just dealt with it a little bit. Now, to what extent, if any, would Article 24(4) of the Constitution narrowed down the possibility of derogation from the right of equality and freedom from discrimination with respect to Muslims. Then number 2, what are the conditions to be fulfilled before a person can invoke Islamic law to derogate from or limit the right of equality and freedom from discrimination?
Let me start the last one.
Yes.
Which is easy.
Yes.
And this is my position, and this is the correct position.
Yes.
As has rightly been pointed out by the Supreme Court in that case of Faraj, the Supreme Court, the Constitution is a supreme law of this country. All religions, including Muslim religion, is subject to the tenets and the provision of the Constitution. If any belief or action or issue is in violation or infringement of the Constitution to the extent under Article 24(4), then it is void. You cannot say because I am so and so, I want to opt out of the constitutional provisions in terms of equality, in my view.
Okay. Now, I want to go to another area, Judge, the area of elections, and because this is one of the areas that have been highly contested and largely resolved by the court. But there is a troubling case, the Martha Karua case, that proceeded and went all the way to Arusha, where she claimed that the way she was treated by the court was unfair, and then the court gave some sort of damage. That is the East African Court of Justice. However, before that, just to give context, this case was with respect to an election petition which was filed, and there were many applications that were subsequent in the petition that led to the time that was set by the Constitution to run out. But the time was run out by the court, not by the litigant. So that then we have competing principles of law, of one, that an election ought to be determined, and that has been settled also by the Supreme Court within a certain period of time. Number 2 is that Martha Karua was also entitled to access to justice and also to a fair hearing. And perhaps I would just want to hear your views about number 1, how would a court, or how is a court supposed to handle that sort of situation, and what would be your also reaction to the criticism by the South African court in terms of how the courts handle that matter?
Thank you very much. I think you are leading me into a minefield, but I have to navigate.
Yes.
First of all, as I stated earlier, it's not in my place as a court of appeal sitting here to criticize a decision of the Supreme Court. The decision of the Supreme Court is binding on all judges serving in this country below the Supreme Court, and it is only the Supreme Court that can review its decision, and of course in exceptional circumstances. But let me come to the Martha Karua case. I handled the Martha Karua case one time in the Court of Appeal when the application, her petition was struck out. And the question before the Court of Appeal is, was there justification to strike out her petition in view of the reasons and the grounds set by the applicant who succeeded in striking out? Of course, we had, but let me put one caveat here. The matter stayed in the Court of Appeal registry for 2.5 months without being listed. It also stayed 2.5 months before the trial judge. In terms of election petitions, there are dilemmas which I think the Supreme Court should address. There is the 6-month period which is granted to the High Court, and there is the 6-month period which is granted to the Court of Appeal. There is no timeline granted to the Court of Appeal. I don't know why, or to the Supreme Court, I don't know why. So the question, in my view, which should be addressed, and we took almost ourselves 1 month to resolve the matter. So by the time we were taking back the matter for merit hearing, the 6 months were almost over. So that is the dilemma which I think I will beseech the Supreme Court to address, which is whether the 6-month jurisdiction or timelines is shared between the two courts, whether it is concurrent jurisdiction or whether it is consecutive jurisdiction. Do we, for example, say Mother Karua's case was held in the High Court for 2.5 months. So when it goes back to the High Court for retrial, she has 3.5 months. If her time was, for example, used 2.5 months or 3 months in the Court of Appeal, does she have 3 months if she comes back to the Court of Appeal? Those are the dilemmas which I think should have been addressed by the Court of Appeal in the first instance, and maybe give the Supreme Court an opportunity to address its mind. Another issue which I think is also very important and which I think has not been addressed correctly, I haven't dealt with that case. Honorable Mother Karua's case was not an ordinary petition. It was brought under Article 22 of the Constitution. And that's how it was framed. It was framed as a violation of her constitutional rights. So the question that comes to my mind, or that we were also struggling with, does a constitutional violation, whether fashioned as an election petition or an injury, has time limit? For example, the Supreme Court said in the Monica Wamwere, the mothers of the political detainees, there is no time limit for such kind of cases. Is it necessary to apply such precedent or reasoning to a petition filed by Mother Karua? I have no answer. But the point I'm making is, here is a situation where the petitioner is helpless and the court is also helpless. So where do you blame? Do you blame legislation? Do you blame the Court of Appeal? Do you blame the Supreme Court judges? I have no answer. But in terms of what the East African Court has said, I think the answer can be found in the advisory opinion by the Honorable AG, where the Supreme Court said its decision cannot be reviewed or cannot be a subject of discussion in another court, whether it is a court below or another court, whether it is East Africa or another court. But that matter has been settled, but the question of concurrent and consecutive jurisdiction in election matters is something live and which must be addressed. And that is the elephant in the room, whether it affects Mother Karua or it affects anybody else. Thank you.
Thank you, CJ, that's all.
Thank you. The Honorable Attorney General.
Good afternoon, Judge.
Good afternoon, Honorable AG.
Yes. Now, correct me if I did not record well, but from your opening statement you said that the Supreme Court must speak to the needs of Kenyans. The Supreme Court must question whether it is carrying the people of this country on board. And then you also said you must carry the Wanjikus on board. then you again said the Supreme Court must be sensitive in addressing the needs of Kenyans. Again, in answer to Commissioner Mwanza, you said the Supreme Court must carry the citizen. The Supreme Court must carry the citizen in its decision making. I have a very simple question.
Yes.
I ask you this question cognizant of the fact that you and I believe in the supremacy of the Constitution, as you have said. We also know that public expectations matter in a democracy, and that the court must also be sensitive to public aspirations. But we also know that Article 2 declares the Constitution supreme and binds all persons and state organs, and Article 10 identifies national values, while Article 259 directs the manner in which the Constitution is to be construed. Now, from what you had said before and taking into account the provisions of the Constitution, how should the court handle cases where constitutional text, constitutional values, and public expectations appear to point in different directions?
Thank you.
It is analogous to what you are discussing with Commissioner Mwanza.
Thank you, Honorable AG. Public, we know we must understand, and this is the starting point. Our Constitution was arrived through a rigorous process. It took almost more than 30 years to have a consensus. We could not have a consensus. That is why we had a referendum. And that is why the Reds were defeated. And the Reds were not few people. There were a sizable number of Kenyans. Our Constitution, like any other constitution, is a social contract. And a contract, by its nature, has its own pitfalls. There are people who have strong negotiation arguments. So they may agree, or they may have their issues put in the Constitution or in the document, while others may have a weaker argument or position. So the Constitution is a compromise document. And as C.J. Mutunga said in one of his positions, it has inconsistencies, and it has grammar, and it has many other problems. But it is the starting point. I come to your question. The question is, how do we address? There are two schools of thought. There are judges or scholars who say, no matter your views, we should guard our views, no matter how strong they are, and follow the constitutional text. There is another group which says, look for something that can give rights, the purposive rights of certain group of people who think they did not find what they are entitled to in the Constitution. The point I'm making is, no matter how ardent and strong our views are as judges, we should avoid as much as possible granting or refusing rights which are not found in the Constitution text. Those are my preliminary views.
But do you agree that the courts serve the people by serving the Constitution?
Yes.
And public expectation can be very strong.
Yes.
Where the text of the Constitution is open-ended, it can solve ambiguity.
Yes.
But is there room for amendment of a text, or diluting of rights, or authorization of unconstitutional power by virtue of public expectation and public pressure?
Public expectation or public pressure are not components which can lead to giving a right or denying a right. the starting point and the end point is whether the Constitution provides for the right or whether it prohibits the right. In my view, those are the two criteria. Is the right available under the constitutional text? And then there is something which most judges look at, sometimes even when they are looking for expectation. They say, is it rooted in our history and tradition so that we can give it some kind of leeway in terms of whether it fits within the constitutional text. But it all depends with the interpretation you want to follow and how you want to regard the particular issue. But everything aside, you know, when you're discussing rights and how to interpret the Constitution, it cannot be in hypothesis. It has to be in terms of contextualize the issues. And it is only when a judge has the correct scenarios or the correct context, he will say, this one is available or this one is not available.
I agree that when a constitution has got historical underpinnings, then
yes,
public opinion can help in resolving interpretation.
Yes.
But maybe I will leave this for another day because I'm now trying to reconcile your answer to me and your discussion with Mr. Mwanza about the room for Sharia law and Islamic religion. And I don't think I reconcile the two. Yeah?
Maybe I did not put it as elegant
but
as
we
you
can
want.
do it later on, yeah?
Yes.
Yes. Now, may I just ask you one other question? What should amount to a matter of general public importance for purposes of Supreme Court certification? And I know we've asked this question, we've asked many candidates this question, but I would like to know whether commercial tax or procurement or employment disputes can qualify.
Okay. A matter of general public importance has been defined, I think, consistently by the Supreme Court. In terms of the first case, Hermana's case, and they set down the guidelines. But whether it applies to procurement or commercial disputes, I have no answer. But my answer would be, going forward, I think, in my view, the Supreme Court should leave the issue of commercial disputes, contracts, and procurement issues to the Court of Appeal, such that it concentrates on issues of constitutional interpretation and application. Those are my view.
Thank you, CJ.
Thank you. Justice Murima.
Thank you, Honorable Chief Justice and Judge. Once again, welcome. I will have a discussion with you, Judge, on two areas. And having served as the first presiding judge of Judicial Review Division, let's start with JR. Just to lay the basis for our discussion, just take us through the pre- and post-2010 constitutional legal regimes on JR, just briefly. Thank
you, Judge. The JR pre-2010 was a common law prerogative orders, which only was concerned with the process, the issue of whether the process was right. And you could only issue certain orders in terms of whether the process is right, the issue of Wednesbury, reasonableness on illegality, and process priority. Those were the guiding principles, and the court could only issue prohibition, mandamus, and the certiorari in the correct circumstances. So it was very restrictive in terms of the fact that under Order 53, there was certain requirement before you could file or succeed. The issue of leave and the issue of the decision must be within 6 months. Those were the position before the 2010 Constitution.
Yes, and post?
And then post, there are three issues which happened post. The constitutionalization of JR in terms of Article 23(3), in terms of the enactment of the Fair Administrative Act, and in terms of Article 47, which provided for Fair Administrative Act, the Constitution. And the last issue is also what I will call commercialization of JR through the CJ's commerce rules, I think of 2024. Yes.
Are you done?
Yes.
Okay. I hadn't heard about that one, but I'll look at it.
I had not also heard about it myself.
I mean the 2024 CJ Commerce rules.
Okay.
Yes, on operationalization of the Fair Administrative Act.
Okay.
Yes, that's what I call the commercialization of the JR.
Okay. Now with that background, which is correct, I want us to have a look at two issues. The issue of the pleadings. The Supreme Court, through several decisions, including the Dande case, has stated that you can have the remedy or the relief of judicial review either under the Constitution, as you stated, Article 23, or under the Order 53. And if you go under 53, you may be limited to the issue of procedural review if you do not invoke any allegations of constitutional violations or rights violations. But if you go post that and invoke constitutional provisions, the violations of the Constitution and the rights, then you may be, even under Order 53, you may be entitled to a merit review in that matter. That places JR under Order 53, same as JR under Article 23. But how different will be a pleading under Order 53 be from a constitutional petition in Article 23?
Thank you very much, Judge. Under Article 23, under Article 47 of the Constitution, and the Fair Administrative Act, and the Commerce rules of 2024 have entrenched the JR as a judicial mechanism which is not subject to all the JR of the procedural restrictions of 6 months and leave. The question is whether, under these circumstances, the JR can issue merit review. Under Article 23(3), the orders which can be issued both under JR and constitutional violations are indicated, and I think there are 4 or 5. But the court has said you can issue appropriate orders under JR under the constitutional violation. The restriction under JR 53, the question is, because of the Commerce rules and the Act, does it still subsist? It is still within the statute, Order 53. And I have seen people who have come under Order 53, and because of this, they have not obtained or they did not have the 6 months, their cases was dismissed. And again, I have also seen decisions of the Supreme Court, I think there are 4. The Donde, is it the Dande, which is equivalent to Geller vs. Kasman Brown, which was about propriety rights. The Supreme Court said, of course you can review merit, but under very limited circumstances. And the court enumerated those circumstances. But nonetheless, for example, in the case of Praxidis Namoni against JDC, the company secretary was saying, I did not participate in the tender. But nonetheless, the court said, no. These are issues of merit. Go back. Again, also in the case of Professor Tom Ojenda against the anti-corruption, the court also determined what is administrative and said arrest, search, and surrender of documents does not fall within the purview of an administrative action. So,
Judge, just for clarity, am I understanding you to say that when you take the route of Order 53,
yes,
regardless of what you plead, even if you plead all the rights and constitutional violation, as long as you do a pleading under Order 53, it must comply to the requirements of leave and the timelines.
Yes.
That still remains.
Yes.
And which is that the case? Yes. Under constitutional petitions under Article 23? Yes.
But usually there is a dilemma. The dilemma is under the Fair Administrative Act, and also under the common rules